to partake in this debate. And I must say, when I heard the Attorney General's opening this discussion, he has given a picture of we need this legislation to fight fraud, we need this legislation to bring to fruition all the other pieces of legislation he has put before us. And I think it is really paramount to us to at least give him some sort of legislation that could help him in this effort and could help the country in this effort too. But when he closed his discourse, he actually mentioned a lot of cases where the Law Association did oppose various pieces of legislation that he brought before. So he listed that. So it came like if the Law Association was really, a lot of things that he brought to the table, there was always that opposition. And they may have their concerns, and that is valid. But, Mr. Vice President, I must say, I also have to give a little unfortunate series of events that occurred recently. On May the 7th, 2020, I got an email that actually invited me to partake in one of those Zoom meetings with the Law Association. And in this email actually suggested that Ms. Keisha Peterkin was written to the procedural clerk, and she was given, the opinion that all senators would be invited to partake discussion on this same bill. And lo and behold, the meeting was on Saturday, and only on Monday, the Attorney General had sent some letters, giving some effects that, hey, not all senators were invited. And even Ms. Keisha Peterkin did not even get that email to send to us. So it appeared that it was a little, there was a series of emails between the Law Association and the Attorney General. We were included, but it came to the idea that, what came to the front was that, certain senators were invited, the opposition and the independent, but the government senators were excluded. And I think the Attorney General did put that in his dismay. It also came to the fact that the Law Association wrote and said that we independent senators had asked for an audience with them. And I want to deny this, and the other independent senators could also bear me, but we never asked for any meeting with the Law Association. And this was in writing. I think this is something we have to know why this was occurred. What is this web of deception? Because if we never asked it, it's not it's within our right. I can ask the Law Association or garner information from anybody to help me in the law. But it was, we never had asked it, and I want to clarify that. So therefore, what I'm saying that what came to the discussion is this email was sent to the Ms. Keisha Peterkin, but it was never, I think the procedural clerk said they never got it. So something happened there that caused some sort of what I may say, dismay to me that I felt like I was being used as a pawn. But all as it say, I think the Law Association gives some opinion, and I'm thinking that we need to know what transpired there that causes. But as it may, I am looking at the role of the Law Association. So criticisms were made about them. This scenario developed recently where I'm saying certain things came to light that I'm thinking, why this should have happened, and I don't know. And the other issue I want to know, the fact is we really need legislation to help against the land fraud. We need legislation to help against what's going on in the country where people buy land and suffer. And even up to 2 years ago, I remember there's an attorney down south, he got $75,000 bail for some fraudulent activity. And history has shown different attorneys do, in fact, engage in that. I remember a very high official said there are criminal lawyers and lawyer criminals. And, the opinion is in all fields you may get persons who may dishonor their professions. So therefore, if this legislation also serves to put a cap on certain attorneys who may be on the fringes of the law, I think this legislation is needed. So what I'm saying, Mr. Vice President, we need this legislation. Our Trinidad and Tobago is 5,128 square kilometers of land. We should have been able to have a system in place where the whole idea of land titles, land ownership should have been something that gives us a little more satisfaction all these years. We had countless of attorney generals actually came with certain things on the table, but we are still deficient. And even the specific developmental goals of the United Nations, we have to appreciate that the specific developmental goal, Goal 4, provides that all men and women should have equal rights to ownership and control of land. And this is something that, looking at this developmental goal, I mean, there are different developmental goals, eradication of poverty and amongst other things. So this is something which is our basic right. This is something that we have to look at, meeting these United Nations goals. And even we need to factor in the 250,000 squatters in the land too. Because we are passing legislation to title, but really to look at the equality of man, the equality of land use. I'm thinking we need to factor, yes, the titles, but the squatters. Now, the problem we had here in Trinidad and Tobago is the fact that we have different systems existing. And as the attorneys did point out, that the old systems where people could have, their land, and then they came with the Registration of Deeds Act. So there's a civil aspect, then the Registration of Deeds Act with, claims, and then even as far back as 1884, we had the Registration of Deeds Act, which is about 175 years old. We had the Australian system was brought in. So Robert Torrance brought in the legislation to make it a little more, since 100 and how much, that will be in 1892, there were changes again to try to see. So since that year, attempts have been made, 1892, to see somehow we can make a better system in registration of land. And therefore it's time now, I think, that we actually do something. So you see, I think the real trust came about in 1977, where they had the land reformation was really started. And if I remember, in 1981, there was Professor Wiley, who had packages of laws that he gave. And the Parliament then discussed it, and they were supposed to go forward with those laws. But somehow, it never went further. It was good legislation that we needed, and somehow it was there, it was stuck there. Even after Professor Wiley, I remember there was the Law Reform Commission under the late Justice Guy Prasad. He and the then Attorney General at the time, Ramesh Lawrence Maharaj, did put across some good legislation, pieces of legislation that I'm thinking would have helped us. So all along, we had attempts made to bring in legislation. We had also, I remember, in I think it was around 1980s, we had, 2008, Mr. Vice President, the IDB gave us a loan. And they gave us a loan of $100 million and $7 million to go to Tobago. And that loan really was a loan to somehow cause, to put into place better systems to register land. What happened to that money? Is it still available? Is it in abeyance? Could the IDB take it back and give it to another country? All these things we have to factor in. All that money we got to do something, and we still have not reached that level that we should be in. So therefore, the fact is, I appreciate the Attorney General wanting to have this piece of legislation to factor in the fraud that occurs, to look at the factor legislation, to bring us into tandem with what's going worldwide. Even the EU demands that you have to have better pieces of legislation to look at money laundering, to see how land dispersion occurs, where people could use it against use it for illicit gains, to hide money and whatnot. So therefore, but even though the Attorney General is going after that, and even though the Minister of Finance stated that there's a need to get this money that is out there, I am looking really at the plight of the poor person. Because there are individuals in Trinidad and Tobago who, when they have to do any sort of land transaction, the length of time it takes is one thing. The second thing is, I had a patient, they're very good relationships, and when the parents died, the two children had two deeds for the same property. And it caused a major trouble. So definitely, the people suffer. Definitely, there is a need to have these issues settled earlier o'clock rather than to have to go to court matter that takes years and beats up on the people and psychologically could make them depressed, angry. And these are things that we have to realize, that land victimization occurs. And it's really a nightmare sometimes when you have to deal with these issues. Sometimes you have persons who are Alzheimer's patients who somehow being able to suddenly get a clarity of mind and sign their deeds to their lands. These are things we have to stop. And if pieces of legislation like this could help it, if you can now, if there's any land transaction and it could be there in a registry, so if I know my sister might be going behind my back for my mother to change that deed, I can look at it. You can stop things earlier. So the openness, the transparency is something I think we need to see if we can get at. There's also the situation there, not just with the false deals and the profits. I'm thinking that those, I'm saying attorneys who were engaged in any sort of fraudulent activities, as I'm saying, I mentioned the case, there was a case in South where the law association should use disciplinary measures to show us, hey, we are going after these errant attorneys. There should be a list of attorneys also who, if they involve in any sort of activity, we can red flag them. Now, thankfully, now according to this legislation, they have to be compliant, with, the FIC. So the compliancy issue is there, the fact that they have to be above board, and we put in things in place to make it a little more transparent. But what I'm saying, the transparency, the open access, the need for digitalization of these titles, all these are things that I can stay at home and don't have to line up to go. I could just go into the computer system and see who owns this piece of property, who owns this piece of land. You see, this piece of legislation, if it is there to protect individuals, I'm saying it is much needed. And when I looked at the bill, Mr. Vice President, I realized that the intent I'm thinking is it's there, it's good. I'm looking at the fact that when you are looking at the instance in Clause 3, I just wanted to realize that when in Clause 3, Mr. Vice President, the Registrar General is to keep, an additional index for all instruments of trust, and it should be a closed index. I must say I would like to agree with Senator Mark that I think there's a need for transparency. There's a need for transparency because if you're doing business above board and you have nothing to hide, you should not have any problems in putting that there, that the public could now access to see what's going on. So I'm thinking somehow that close index is something I am in a little disagreement with, and I'm thinking this should be changed. I looked at the fact that under Section 7.2, when we had the initial bill, some of the fees were very high, like the registration of a contract for the sale of land was $2,000 and whatnot. And I realized with this amended version that the Attorney General came back down to $200, which I think it is where it should have been, not the inflated rate of $2,000. I would like to say that when I looked at the Section 5B, and in Section 5B, where the deed is executed in Trinidad and Tobago, in the presence of at least one witness not being party to the deed, and a qualified functionary, and the deed signing and delivery. So part of the condition, you have to get one witness. What I'm saying, Mr. Vice President, with all the fraud that occurs, I am saying we could have put it as part of the legislation that 2 witnesses. So at least it gives us a little level of protection. I've seen people in the hospital dying, and sometimes their relatives will come in and want them to sign a deed or to give a fingerprint. I'm saying no, have 2 witnesses, not just one. At least we could protect and ensure that proper things are being done. When I looked at the execution of instruments by marksmen, which is proposed Section 5D, and at that it mentioned that the certificate on the deed, that when you're going to have this deed, you have to have an attorney at law or just a duly licensed interpreter being one person to give like this signatory of the deed. I am saying, Mr. Vice President, sometimes you have persons who have to give a mark, a patient with a stroke, a patient who, for some reason, cannot read or write. I'm still thinking in cases like this, somewhere along the line, we should have factored in that.
Senator, you have 5 more minutes.
Sure, thank you. Mr. Vice President, something we should have factored in there, that a doctor to be present to give a competency test. Because you see, if you have to give a mark to, and a patient is there, okay, if they cannot, they're unable to write, this is one thing. But if it's cases where you have people giving fingerprints, I'm thinking factor that in, that we should have had a doctor being present or somebody there being present that could attest to that person's, mental state, because this is something that we are seeing more and more, that we are having to deal with as doctors too. That recently I had a patient who made a deed, and the patient was definitely demented, and after the legal action came out, I was asked to come and give evidence to say that patient had dementia 5 years ago and could have no way give a proper signature to that. Mr. Vice President, I looked at proposed section 15B, where it is said that the Attorney General or his authorized clerk should have to give a notice within 30 days for the execution of the contract. And it is clear that some contracts remain there in Netherlands, I would put it, Netherlands contracts where is a state of limbo, where the intention of that would really be to some sort of matter of fraud where you just leave it there. And the Attorney General did give that so I commend that aspect to say that we have to give the level of when these contracts started, when the deal was started, at least to have that notification. I also would like to support Senator Mark's idea where he mentioned that so many different registers you need now. It may cause a bureaucratic delay unless the system is somehow fine-tuned or digitalized. I'm thinking we may need more staff there, but the Attorney General did say that this wouldn't be complained unless it starts to be, in a way, actualized with more staff. And I looked at the other pieces of legislation, and I'm thinking that the aspect of it where you are giving the attorneys, you're putting a fee to the attorneys or a punishment to the attorneys if they do an offense and do not portray this deeds on time. I'm thinking the attorneys may feel we are criminalizing them, but the idea is things have happened. Some of them may have been, part of the problem. And I'm thinking if this goes away, it goes in a way to somehow get them to do what is demanded of them, the proper thing, I have no problem. But I saw there was a change from a 10,000 and imprisonment to just a percentage of the fee. And I think probably the AG gave way there, but I was willing to support that 10,000 that was in the original piece of legislation. So I must say, Mr. Vice President, I think that this piece of legislation here is needed. I think they need to at least to have the legislation in place now. After so many years, we need to do something. The fact that Tobago has a different system, I think that's a little strange, because if equality before the law is there and the land distribution in Tobago is different, that comes like a geographical discrimination. Because if you're trying to get title in Tobago, it's different from Trinidad because of the events in Tobago. But some people may look at it as an inequality before the law. So I'm thinking we need to digitalize, we need to make it more transparent, we need open access, and we need to open up the system to protect the small man and the citizens from the atrocities that exist. Thank you, Mr. Vice President.
Senator Deanna Ryan.
Thank you, Mr. Vice President, for the opportunity to contribute to the debate today. I would be brief in my contribution today because I have mainly 2 points that I would like to highlight. So, Mr. Vice President, the first thing that I want to say is that land administration and registration of property in Trinidad and Tobago is something that is very outdated and complex. Right now we have a system where we are conducting land transactions in an archaic and vulnerable administration system that serves as a breeding ground for fraud to take place. So, Mr. Vice President, the complex nature of our land administration is reflected in our performance in terms of the Ease of Doing Business Index. And this is actually where my main concern is. Senator Sipasat actually alluded to the fact that right now we rank 105 out of 187 countries, according to the latest World Bank calculation of the Ease of Doing Business Index. But what is interesting, Mr. Vice President, is the fact that registering property, that particular indicator under the Ease of Doing Business Index, actually is one of the indices that causes the entire Ease of Doing Business Index to be significantly low. We actually rank 158 out of 187 countries when it comes to registering property in Trinidad and Tobago. So when you compare that to the rest of the region, we are actually way below average for the Latin America and the Caribbean region. Jamaica, Grenada, and the rest of CARICOM performs better than Trinidad, with the exception of Dominica. That's the only Caribbean country that we perform better than. So, Mr. Vice President, without this legislation even being in effect, we have a situation where, on average, it takes approximately 77 days to complete a land transaction. It takes 9 procedures, and it accounts for 7% of the cost of the property for which you are conducting the transaction on. That is the cost of the transaction. So when you look at this legislation, with the amendment, inclusive of the amendments that would have been circulated by the Attorney General, from a fraud perspective, it is a very good step. But, Mr. Vice President, what I am worried about is the effective implementation of this law. The enforcement of the law in an effort to reduce land fraud would mean that now we are increasing the number of procedures. So most likely we're going to move from this average 9 procedures that it takes to conduct land transactions to a larger number. It lengthens the process. So it may very well take more than 77 days to complete a particular transaction when it comes to the purchase and sale of property. And now, because we have a situation where lawyers are more accountable and liable, because now they are the main stakeholder, the main persons involved in conducting the transaction in this new system, their costs too would also increase. And this would most likely mean that it would no longer just cost 7% of the cost of a property to complete a transaction. It may very well go up. Now, Mr. Vice President, all of these factors that I've discussed actually feeds into the actual calculation of the Ease of Doing Business Index. And therefore, that aspect of the Ease of Doing Business Index, the property registration aspect, would be even worse. So the second concern that I have, Mr. Vice President, has to do with the administrative framework. Now, I'm not entirely confident that the required administrative framework to implement this is in place. What we need is a robust and sound administrative framework, which is critical to carry out this law. The main actor in this administrative framework is the Registrar General Department. And yes, I have to admit that the department has undergone significant strides in terms of its move towards automation. They have moved significantly from a completely manual system to a good bit of automation. However, Mr. Vice President, we cannot depend only on the property business registry system to solve all the problems. It's not just about getting the system up and running. What we have to be cognizant of is the fact that when we are undergoing a process of modernizing archaic system, there tends to be a resistance to change. And they also have a significant tendency towards wanting to continue to operate in a manual mindset. So for this legislation to work, Mr. Vice President, you need to have the RGD completely automated, yes, but you need to also have significant change management in the transition. We need the persons to get the persons behind the system, behind this automated PBRS system, to get out of the manual mindset of doing things. In addition, the administrative system must be integrated with other stakeholders involved in land administration. Right now, we have too many players with limited interministerial and interdepartmental coordination. It is critical that we communicate not only within the Registrar General Department, but also amongst other public offices that are key players in the land administration system. These divisions are Land and Surveys Division, Stamp Duty, Commission of State Land, Inland Revenue, HDC even to some extent, and also regional corporations. All these agencies have a role to play in land administration, and communication is lacking significantly amongst those departments. What is currently happening, Mr. Vice President, is that we have a situation where everyone has developed their own little system and their own little way of doing things, and they operate in silos. I say this because I've seen it, and it is a problem not only in RGD, in the Registrar General Department, it is a problem across the public service. In my experience working with a multilateral lending agency, anytime we had a situation where we are trying to implement a project which involves radical change and radical transformation in systems in Trinidad and Tobago, what we found is that a lot of times we have to play the role where we spend a lot of time with conflict management, getting departments to actually talk to one another, to know what it is each other are doing. And also, many times we act as an intermediary for interministerial coordination. Because these ministries are simply just, and departments are simply just not talking to one another. And that coordination that is required for radical change is not there. So it is a reality, Mr. Vice President, and it needs to be given strong consideration. Mr. Vice President, the last point I want to raise is with respect to the legal framework for doing things online. Now, I expected to see this legislation laying foundation for a legal framework to do things online. To me, it doesn't create that framework for being revolutionized, a digital environment. And this is a major, major drawback when it comes to the World Bank Ease of Doing Business Index. A lot of things cannot be done online. I don't see the legislation being accommodative to eventually take services online. Again, we are reverting to these paper-based forms, which must be completed and submitted in hard copy. Some forms don't provide space for email addresses in some instances. When we reach at the committee stage, I will draw reference to them. And even though some clauses require the Registrar General to give notice, both in writing and electronically, there are forms in the schedules that does not provide a space for the clients to provide that information. So, Mr. Vice President, that is all that I have to say. During the committee stage, I would drill down to the clause-by-clause issues that I have. Thank you, Mr. Vice President.
Senator Hussain. Thank you very much, Mr. Vice President, for recognizing me to join this debate on the Miscellaneous Provisions Bill 2020, which deals with the Registrar General, registration of deeds, conveyancing and law of property, real property, stamp duty and registration of title to land acts. Now, Mr. Vice President, this particular piece of legislation, it's one of the most far-reaching and has one of the most extensive reach if this piece of legislation is passed. And I say this because coming out from the jurisprudence in terms of land law in Trinidad and Tobago, there has been hundreds of years of settled practice and law that can be affected by this particular piece of legislation. Some welcomed and some may not be welcomed, some fixed and some cannot be fixed. And we have to understand the climate in which Trinidad and Tobago finds itself. And because of our history, you would realize, Mr. Vice President, that over time we were governed by several different states, and we would have adopted their laws in Trinidad and Tobago. And the end product is that we ended up with two systems of law in terms of registration. We have what is called the common law system of registration, and then we have what we call the registration under the Real Property Act. So it's two different systems we have. Currently, the registry at the Registrar General's office has two different registries. One that receives and registers common law conveyances, which everyone might be familiar with, which if you have a deed at home, you'll see them on the legal size paper. And then you have the RPA, the Real Property Act, where you have the large certificates of title, which are the instruments, and at the back of those instruments are endorsed with the various transactions of the land over time. And some persons, they call them you'll see them as crown grants also. And that is the difference, Mr. Vice President, because in the common law system, in order to determine who has title, the chain of title must be proven. And how the chain is proven is that based on several years of registration of several deeds, you will see how one particular piece of land or an interest in the land or part of the land has been transferred over time to several owners. And in the real property sense, you will see endorsed at the back of every certificate of title the transactions that would have occurred over time. And the real property system, you would also have assurances by the state in terms of the guaranteeing of title. So that is a more protected manner in which land is registered in Trinidad and Tobago. Now, you would remember, Mr. Vice President, that in 2018, this Senate was asked to consider and pass amendments to what we call the suite of land legislation. And this suite was passed in the year 2000. And you remember, we had the Land Tribunal Act, we have the Land Adjudication Act, the State Suite Limitation Act, and also we made amendments to the Registration of Deeds Act. And registration of titles, sorry. Thank you very much. And you would remember that the policy of the government was to take these two streams and bring them into one. So therefore, we have one proper registration system of land in Trinidad and Tobago. That Trinidad would have had now one registry in which we would have all of these lands converging. We're also told, and several senators raised this, especially Senator Dylan Remy, in terms of the issues that Tobago has with respect to the titles of land in Tobago. So I say this to say, Mr. Vice President, is that we are now trying, in this instance, to reform especially the common law system of registration. So I asked the Attorney General whether or not there's a shift in the government's policy with respect to those pieces of legislation that we had passed to what we are doing now. Because what we will be doing now is expending resources to set up various and additional registries when we could have been directing these resources at getting the system set up that we all agree to in terms of the suite of legislation that was passed in 2000. So whether or not we are channeling our resources in the wrong direction at this point in time. I know also, Madam President, I welcome you back to the chair, is that yes, we have our obligations to the Financial Action Task Force. Yes, we did well in terms of our mutual evaluation. And I understand that part of the bill would have dealt with trying to address some of those recommendations, namely Recommendation 25, which deals with beneficial ownership and the setting up of registries with trust. So I understand that part of the bill, but I would also pose this question to the Attorney General, whether or not the other parts of the bill is going beyond what is Recommendation 25 and what FATF had asked us to do. I know in the piloting of the legislation, the mischief that we're trying to fix here is fraud. Now, Madam President, all of us in the Senate, I think, will agree that there is some level of fraud in the society when it comes to land, because we have seen several fraudulent land transactions previously. And we as a Senate agree that yes, this must be something that we address. But we have to also examine the legislative framework that is being put in place, whether or not we are going to reach that legislative aim in terms of fraud. Because what the Attorney General is asking us to do, and this bill was in fact examined by members of the Law Association, is that some members believe that this particular bill really isn't addressing what the aim is. Whether or not this would in fact combat fraud. Whether or not this would decrease the number of fraudulent transactions that take place with land. Because when you look at the current framework and structure, attorneys at law now fall under the ambit of the financial, the FIU, the Financial Intelligence Unit. When land transactions take place, they have their Know Your Customer forms and also the AML CFT guidelines. Also, when persons withdraw funds or deposit funds with land transactions in the banks, they have to declare a source of income or why they're withdrawing so much money in terms of transactions. And you would have these individuals presenting deeds, agreements for sale to the financial institutions in order to access the funding. So I'm asking whether or not this dual registration system in terms of registering agreements for sale will in fact really allow us to reach our legislative aim, or whether or not we already have it, or whether or not we should just go back or expend our resources to the system that we had agreed to way back in 2000, because it's 20 years had passed, several administrations, and we have yet to see the setup of that registry. So those are the issues in terms of the policy of this particular bill I wish to raise in this particular debate. Now, Madam President, you would also have in this particular bill, and if you remember, the bill that we previously dealt with, which relates to the real estate agents, in terms of the cost of transaction, and I believe Senator Deo Narine would have spoken to some of these aspects, whether or not now land transactions, the prices, the complexity will increase as we go along in terms of this, which can affect an already burdened economy in terms of the ease of doing business. Because we have to also look at those issues when we pass legislation in this Parliament. Now, Madam President, I want to drill down in particular to some clauses of the bill that I had outlined, and if you would permit me, Madam President, I know that we have the bill that was laid in the House, but subsequently a marked up version of the bill was given to us with further amendments. So I want to examine the two bills, Madam President, namely the marked up version, although I know it's not before the Senate, but it will facilitate the debate, especially with respect to our time limitation. So I want to look at the definition at Clause 4 in terms of the definition of interest in land. And I note that the Attorney General did in fact accept the recommendation of the Law Association with the deletion of equitable interest for the definition of interest in land. Because as we know, that in fact will cause some level of ambiguity as we go forward, because once the legal instruments are registered, you will have the legal interest passing, and sometimes the court is asked to adjudicate upon what might be considered an equitable interest, which is something that is not in particular registered, because it all stems from the person's contribution dealings in the particular property or land, Madam President. Now, I looked at clause 4, and this at clause 4D in particular. And at clause 4D, it dealt with also that every instrument, every registrable document executed in Trinidad or elsewhere can only be registered under this act in order to be valid and effectual in law. Now, what does this tell us? This tells us, Madam President, that title to property passes on registration. As is the law now, is that in common law transactions, title passes on execution of the deed. In RPA, real property, lands that fall under RPA, title passes on registration of the documents. So that is the difference. Now, what the Attorney General is proposing is that common law conveyances, title only passes on registration. Now, I saw the exception being created for mortgages where it provides that section 32A of the Common Law and Conveyancing and Law of Property Act shall continue to apply. And that, Madam President, what does that say is that that section in particular of the Act, it provides that when a mortgage is discharged, the old rules continue to apply, whereby it will take effect on execution rather on registration in section 32A of the Conveyancing.
That's the feeding of the title aspect. That's to allow you to convey the property even though the release didn't happen yet. So that's the mechanism by which you cure the title. You can file the mortgage of the deed of release after and cure the title. So that is what you call the concept of feeding the title. It's not what you've just described.
Right. So what we're saying that as what we are proposing here, Attorney General, is that the law will continue to apply as is. So we maintain the status quo with respect to mortgages. But with respect to other instruments that fall under the common law system, title only passes on registration. On execution. But I looked further down on the bill, Attorney General, where it is now deemed that the date of registration will also be considered the date of execution. That is found at clause 15. Yeah, and I'll get to that particular point. But that is what we're seeing, some sweeping changes with respect to common law conveyances. Now, what we're also looking at, Madam President, is that at clause 4G dealt with some aspects of the Registrar General may refuse to register any deed executed and so on. Now, the Law Association, did comment on this section, and they said that it left some level of discretion because now we're making all registration mandatory under the Miscellaneous Bill, and the use of the word may in fact infer that you can have a different system of registration. So I think they just wanted to make an amendment with respect to making it more directory in terms of using shall rather than may in that particular instance. I want to look at clause 15. Madam President, may I ask how much time I have again?
You finish at 10 minutes past 2.
10 minutes?
Yes, past 2.
Thank you. Now, I want to look at clause...
And you now have 5 more minutes.
Thank you. I want to look at clause 15B. Clause 15B dealt with the registration of agreements and contracts and agreements. And this is with respect to agreements for sale. So what the Attorney General is proposing is that any agreement for sale that has to now be prepared by an attorney at law has to be registered. And the registration system for that must take place within 30 days of full execution of the contract or disposition. Now, there's also provision for late registration. If a person decides to register late, I'm saying all he has to do is make an application to the Registrar General. Now, the Law Association previously had some issues with giving the Registrar General inadvertently some quasi-judicial function, because that could seriously affect the certainty of the sale of land in terms of at the completion of the transaction, whether or not the Registrar General will accept the instruments. Now, whether or not we are giving the Registrar General a discretion. So what will the Registrar General consider in terms of giving approvals or extensions of time with respect to the registration of agreements for sale? I also note, I think Senator Sobel has mentioned it, that it's now restricted to attorneys at law being the only person who will be able to prepare and execute an agreement for sale. Because far too often, Madam President, you wouldn't believe this, is that a lot of justices of the peace in Trinidad and Tobago prepare contracts of sale for land, and you will see that there are certain errors because a contract for sale of land has certain stipulations and requirements by law that should be present in order to have a proper sale going forward. And that is something we have to look at. I know there will be an argument that we're restricting it to attorneys at law, and maybe attorneys may be able to benefit from this particular amendment, but it creates some level of certainty with respect to doing transactions going forward. I also noticed that at clause 15C, a new regime based on the proposed amendment is being put in terms of some further forms, notice of variation, termination, and rescission, and the notices of objection. I know my time is very short, and I note these particular sections. Suffice it to say, I will expand in the committee stage, is that I believe, Attorney General, this will cause some level of bureaucracy, further bureaucracy in the system, because now you would have persons having to file notice of variation or termination or rescission. Then the person will have to file a notice of objection, and when these things go before the court, you will also be filing caveats in some instances. You will be filing certain list pendants in certain circumstances. So there will be a host of various instruments that will have to be filed now when you're going forward with respect to a contentious application or a contentious claim before the court to determine the rights of the owners for a particular piece of land. Clause 15. 15G. Right. Clause 15G again, this is the extension of time for registering a document, which is 12 months now from the date of execution. Attorney General, before I close in 1 minute, I just wanted to get some further clarification too, is that if we're going to now move the system of common law registration for the date of registration for title to pass, what happens in the instance, or even in this instance where you have 12 months to register, if a caveat is lodged and the Registrar General is not in a position or legally bound not to register any deed or instrument based on the lodging of a caveat. Right, exactly. So it will apply for RPA only in that instance. Caveats. In this instance now, with respect to if a list pendant is filed, what is the position of the RG for a common law, so that they will file the deed although the existence of the list pendants, and also whether or not this will affect some persons going forward with transactions in terms of getting land without encumbrances, because what we can see is that if you're taking effect on registration, that period between execution and registration, there can be a judgment being registered, or if the land or some other transaction with the land. So all of those things we could probably address at the stage of the committee. And I thank you very much, Madam President, for your indulgence.
Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam President. And Madam President, an overarching theme has been the risk of business becoming more complex to do, the risk of fees being increased, and the risk of land transactions becoming too expensive. I listened to Senator Deonarine in particular. And Madam President, I would recommend to all my colleagues, those who love lawyers and those who don't, to read the 2008 book written by Richard Susskind. I love the title, Susskind, S-U-S-S-K-I-N-D. The title is The End of Lawyers. And as a solicitor, I enjoyed reading it. But what Richard Susskind really tackled, because I myself, Madam President, in 2014, while I was practicing in Canada, I was shocked. Overnight, the Toronto-based firm of Heenan Blakey disappeared, the 7th largest law firm in the country. More than 500 lawyers just collapsed. With law firms, Madam President, they use the word collapsed. And that is because of something that had been happening in the way legal services were purchased and provided. In fact, the book, The End of Lawyers, there's a subtitle to it, Rethinking the Nature of Legal Services. And what had happened across North America somehow never got to Trinidad yet. What had happened was the big clients, the mining companies in particular, and the banks, they decided to take matters in their own hands and determine what they were going to pay for legal fees. And they started to dissect all the work that they farmed out to law firms and decided those types of work that could be best provided in-house, those types of work that had to be farmed out, and in the case of those things to be farmed out, who it is going to go to. And they chose persons who were reasonable, available, accessible, and experienced. And what it meant was that the work was being spread all over. Companies found that their work was being done in an efficient manner and in a cost-effective manner. So, Madam President, I will answer that overarching theme that I've identified by saying technology, electronic forms, and prescriptive legislation actually helps us in being able to remove the bureaucracy and the inefficiencies of transactions, reduce the cost of having transactions performed, reduced the time and inefficiencies, and allow us to perform them in a less expensive way. And COVID-19 have showed us how we could do that. That anybody, without the bricks and mortar and the air condition and the downtown rents to pay, could perform legal services on a laptop or smartphone from home. And from where I sit, Madam President, that is what I see. I see the potential for a more structured way in which we provide conveyancing services, a process that is defined and set out in the legislation, and we see the sort of forms that work well in an electronic environment. And we see so many instances where there are checks and balances in the system that will achieve the objectives of the legislation. So I want to tell my colleagues, all my colleagues, that there will be some unease Because across North America, when the big companies were changing the way they do business, there was a lot of unease. But out of that discomfort, we've gotten a lot of progress. And it is about time we progress along the lines that we set out to do, as I said when I spoke on the Real Estate Agents Bill, as we set out to do back in the 1980s. It's been a long and largely bad history in dealing with land. Madam President, those of us here and listening who passed through a law school anywhere would have heard this thing about the systems of land administration and conveyancing and so on. I listened to everybody so far. Some people defined it as two systems. That is the one we were taught in law school, the two systems. The Torrance system and the old law system. Not long after you discovered, depending on how long you were in practice, it didn't take you long to find out in Trinidad we had three systems. The Torrance, the old law, and the unregistered system to which the AG has referred, and which is one of the main things we are attacking in this legislation. This unregistered system. Because we know if you spend 5 minutes in a land law class, they will tell you you don't really need a deed. You need a memorandum, a record. You could dip in your back pocket and pull out a whole receipt and write a memorandum in relation to land. So we've had this third system, this unregistered system. But I dare say there's a fourth system. And what we have in Trinidad, we have four systems of conveyancing. We have the old law, the Torrance, we have the unregistered system, and we have the fraudulent system. And Madam President, the most frightening thing to me, I thought I had seen it all, but I believe it was last year, 2019, when someone who had witnessed a highly fraudulent land transaction deposited the documents on my desk. And it related to signatures which were forged, stamps which were fabricated, and a complete fraudulent transaction which passed the muster of one of the largest financial institutions in this country. And in respect of which that institution granted a $6 million mortgage. So this was not petty fraud, this was not snake oil salesmen. This had become big business, and in half an hour, that package was dropped off to the Office of the Commissioner of Police. And most recently, I was informed by that office that they had made substantial progress. But that troubled me. It troubled me that the transaction could be so fraudulent, but yet so clean, as to pass muster with a large financial institution and support the granting of a $6 million mortgage. I also had to deal, and it was on a Sunday Express front page. It shocked me that a lady had been making fortnightly payments and receiving receipts in the name of the HDC. A mortgage constructed, naming law firms and lawyers and all of that, a properly constructed mortgage transaction in respect of two properties owned by our ministry. And I was shocked at how brazen they were, but more importantly, how convincing they were to get this lady to part with her money on a fortnightly basis over a period of several years. And if I had not been the sort of minister who shows up all over the place at any time, I would not have found that lady doing renovations to these two properties as though they were hers. And possibly in her mind, they were hers. And I could stand here all night, Madam President. But this law and these changes are required. We all grew up as lawyers in this law and equity. And it is the only disappointment, really, for me, that we are not likely to go there. The AG has proposed some amendments to the bill, and the amendments include removing the reference to equity. So as it stands now, the two streams continue to flow side by side, and we still have legal rights which are registrable and equitable rights which are created in the form of constructive trusts or other developments on the equity side. And we, in the original bill, the bill that is before you, wanted really, as they said with Lord Keynes' law, the waters to merge, and that equitable interests, whatever they are, should be registrable interests. But the AG, based on consultations, and I was there with him throughout the consultations, extensive consultations, I dare say what he would not tell you. We spent 2 hours with the Law Association on the word mortgage. And I fell asleep, Madam President, and got up and met the discussions exactly where I left them. I was tired. But that is the extent to which we've consulted on this bill. But that provision, the AG proposes a change in what was originally 4D. In 4D, clause 4D that is proposed, we originally had the insertion of a new 2, but the reference to equity in there will be removed. Madam President, with overheated prices in the country for land, with low availability, and with challenges to affordability, fraud has become rife. And in the 3 objectives stated for the bill, the very first one is to deal with fraud. We could not have put it in simpler language. To deal with fraud, to create transparency, especially in relation to beneficial ownership. And beneficial ownership is not something that is new to us in the Parliament. We have tackled that in various forms, in particular in the companies legislation, dealing once and for all with the issue of the beneficial ownership of shares. We go further now and deal with beneficial ownership in relation to land. And that meets, in part, the 3rd objective of the bill, which is to satisfy the international agreements we've made, in particular those dealing with the FATF. So, Madam President, I would say that there are five things that this bill brings to us. The first is certainty. I disagree that it would make things more complicated. I agree. Initially, it will make things a little chaotic because our profession is slow to change and conveyancers and solicitors are even worse. But it would bring certainty because the use of forms, and the AG, I'm sure in the wrapping up, will talk about the substantial progress that has been made on the IT backbone to drive the use of technology in the provision of legal services and the administration of legal transactions in the country. The second thing it would do, it would provide some credibility and verification. Madam President, I listened to my old boss, Ashmead Ali, in making his submissions in relation to what is new, and that is the requirement to register contracts for sale. And that, to me, would make it easier for anybody dealing with land. Because, Madam President, in dealing with Caroni 1975 Limited, for example, where we've had over, on one hand, in relation to the residential parcels of land under the VSEP, we've generated more than 7,000 deeds in respect of that. We've generated, on the one hand, with the 2 acres, we've generated about 8,849 deeds, and on the 2 acre, on the residential lands, we've generated about 7,246 deeds. That's 15,000 deeds. That is 15,000 opportunities for people to sell the same parcel of land. And in some cases, find themselves in the hands of the police. So some people have gone around and offered the same parcel of land because there's no need. The only thing that is registrable is the ultimate document of transfer, the assignment of the lease. But in some cases,
Minister, you have 5 more
for this,
minutes.
thank you, Madam President, for the sake of a bargain, you may withhold even the registration of that. And we say here, in relation to leases, that there is no need to register the contract for this, a contract for the sale. But we also say that it is not to be abused, so we've said that if a contract for sale or if a lease is being transferred at a premium which represents the full value of the land, then we know you are doing the lease as a device to escape registration of a contract. So we've given thought to it. We've given thought to facilitating some of the concerns or many of the concerns of the Law Association. But as far as possible, we've tried to keep our legislative objectives on track, because this legislation does not work alone. It works with the real estate agents bill, the people who will be involved in the land transaction. If you remember, we talked about all the documentation, and I talked about mistakes in stating acreage and so on, and the need for certainty, the need for documentation, the need to be able to be accountable. So this works with that. To answer Senator Ramey, I would just remind Senator Ramey that that matter in relation to Tobago was addressed. You weren't, I don't believe you were in the House as yet, but I always refer to that evening in June 2018 when we debated and we passed 3 of those 4 bills. And the AG gave us his shortest winding up on those bills. He stood up and he sat down on, I think, 2 of them. But the suite of legislation, and it was specified that priority will be given to Tobago, and those changes address the 2 most important things you addressed, Senator Dylan Ramey. You asked about registration of title and the cleaning up of that, and secondly, the special court, which is why we modernized the land tribunal to deal with those boundary disputes and those other issues in relation to title as part of the cleaning up process. A lot of technical work has gone into it in terms of cleaning up the survey plans that we have for Tobago. We've been working on the way we have to do it in the public service of fleshing out the job titles which are stated in the bill, in the legislation, and proceeding to go to cabinet to do the advertisement and the recruitment of persons for those positions which are in the legislation, so that we could start the work in Tobago. So what you've asked for is significantly advanced, and unfortunately in the public sector we take a long time to do things, and that work I expect us to start seeing the fruits of it. And to answer a point that Senator Hussain made in relation to the same suite of legislation, I don't see the need for. You asked if we've abandoned that and doing this instead. The 2 have to be done at the same time. The 2 work together. It's neither one nor the other, because we do in fact have, and we will have with us, an old law system, and what still remains are more modern systems, while at the same time the Law Association is advocating for a completely new system where we could provide a guarantee of title. Madam President, with those words, I say certainty, verification, transparency, which is one of the objectives of the bill. I spoke about duplication. I think the registration, the more information we cause people to put on record in relation to a title, the less likely we are to have duplication of transactions and the opportunity for fraud. And again, just as we did in the real estate agents bill, this bill requires a similar amount of detail to be provided in relation to a transaction, and that minimizes the opportunities for errors, mistakes, and most importantly, Madam President, fraud. I thank you very much.
Attorney General.
Thank you, Madam President. I wish that the benches were full because I know that downstairs it's very hard to pay attention on the television. So I do hope that honorable senators are paying attention. May I thank all honorable senators for their contributions today. The perspectives and recommendations are duly noted. Madam President, Senator Rambrat gave a very good wrap-up of the issues, that there are more than one systems of registration afoot. The land registration system in Trinidad and Tobago is the common law or old law system, the manner by which we register deeds. A deed is only a record of a transaction from one party to the other. A deed does not certify the title that you're dealing with. It says A and B entered into a contract in relation to a piece of land, if we're talking about a conveyance, and it just records that fact. To figure out who really owns the property, you have to do an investigation of title. The investigation of title in the common law is where you go back to something called a root of title, and the root of title is what the law determines in its formula to be something which is fairly unassailable. For example, a deed of mortgage. A deed of mortgage is viewed to be a good root of title because it's assumed that in a 20-year period, if you've got a deed of mortgage, that the bank did good due diligence. And therefore, you work your way up. Once you find a proper root of title, you check every deed along the way to make sure that it appears to be in order. The second system of registration is the RPA, the Real Property Act. The Real Property Act has been around since before 1900. We have brought that from ordinance into act, and that Real Property Act is the closest thing we have to a fairly guaranteed type of system. Originally, all lands in Trinidad and Tobago were supposed to fall under that system, but that system never really came to life because it was voluntary. So only about 20% of our land title is in the RPA. But in that system, your title is fairly good because you have a certificate of title or a crown grant, and everything that happens on that transaction process is recorded on the back of the certificate of title. There's a memorandum of mortgage, memorandum of discharge, memorandum of lease, etc., etc. The third system that we actually have on the books of Trinidad and Tobago is the registration of title to land system, which came about in the land package of the year 2000. The Law Association beat up, screamed, bawled in 1986, 1986, 1987, 1988, 1989, and so we went all the way up to the year 2000, when Attorney General Ramesh Lawrence Maharaj brought the registration of title to land package, and that law has never been proclaimed. That's the third system of registration. The fourth that Senator Rambrat referred to is the fact of an unregistered system, where people hold on to an element of the common law or old law system. They do a deed, they pay their stamp duty. Why do they pay their stamp duty? Because there's a heavy penalty for late stamp duty. It's exponential. And then they sit down on it. That system is where the fraud happens. Now, may I address in the round a number of concerns? Let's start off with Tobago. The Tobago land system is in shambles. In Tobago, in particular after Hurricane Flora passed, a lot of people lost their documents. Tobago has an ancestral system where land was partitioned and divided over time from the estates into people's hand, and Tobago has a lot of what we refer to as possessory title. People just don't challenge the fact that their grandfather and great-grandfather had it, but they have no piece of paper in their hand. Either it was destroyed in the hurricane, or it was never converted properly. People in Tobago have been forced to go through the Real Property Act, to bring the lands under the provisions of the Real Property Act, to convert their possessory title into real property title. But that cost them about $60,000 to $100,000 per person. The reason why land title in Tobago has not worked is that nobody bothered to operationalize the Registration of Title to Land Act, where the state takes the opportunity to cause the mandatory conversion of all title in Trinidad and Tobago, RPA or common law. You feed it into the Registration of Title to Land Act. You go and you declare a zone as a zone. You begin land adjudication. You feed it into the system. A tribunal decides whose land needs to be worked out or not. But that cannot happen like any other law unless you have plant and machinery, people and processes. We have, in the last 5 years under this government, under this Attorney General, this Minister with responsibility for lands, as Senator Rambarat is, we have digitized millions of documents at the registry. We have taken the IDB loan. We have converted all of the maps, the GIS information system, because Senator Dionarine was right. Too many silos where people don't talk to each other. We have purchased the property business real estate solution. Senator Dionarine is right. Nobody was worrying about electronic filing. They were confined to paper-based. Nobody looked at electronic payments because our ease of doing business really and truly fell apart because you're confined to a paper system and you can't pay online using an online service. So the Tobago title gets fixed. Beginning June of this year, we are in the month of June right now, version 3 of the property business real estate solution goes into effect. We will test it with the lawyers, June, July, August, September, and then we will take that system live in September and begin converting the Tobago title into absolute title. Why? Because we bought the software, we bought the hardware, we digitized all the information, we did the geographical information surveys, we did memoranda of understanding between Board of Inland Revenue, Municipal Corporation, all of the state agencies. Planning Division now talks to Fire, Municipal Corporation, OSH. All of those agencies are now integrated, and therefore we allow the systems to go online because, as Attorney General, I have already passed the financial instructions into effect, and that is why you are able to pay for government services at the Registrar General online. Senator Dionarine raised the point about this law not dealing with electronic filing. It's not this law that's going to deal with electronic filing. It's the Electronic Transactions Act. That act came into operation in 2011. No one bothered to operationalize it. This Attorney General operationalized it, which is why you can now do your services online. I can tell you that in the miscellaneous provisions bill that we will bring shortly, in a week, we are dealing with the final bits of signatures. The property business real estate solution allows for the electronic filing of documents. This reality is finally upon us. But you can't operationalize law. You can't stop silos from operating independently unless you introduce plant and machinery, people and processes. Let's deal with people. The Registrar General's office has had a 66% increase in staff. Because the public services have taken long to give the permanent employment, we absorbed a massive increase in staff using short-term employment. We have converted that short-term employment into 3-year contracts. And that's why we have, as Senator Sipasad raised it, the issue of short-term employment. Let's deal with the other factors now surrounding the legislation itself. Madam Speaker, Madam President, this law is not about the Financial Action Task Force Recommendation 25 or Immediate Outcome 5. No, sir. No, ma'am. No, Honorable Senator. This law is about fraud in Trinidad and Tobago. The fraud that is perpetuated in Trinidad and Tobago, Senator Sobers painted it very sharply and very well. It's about people being made victims by other people who go and change their name, pretend to own a property, because I can change my name to Senator X, go and do a deed poll for it, get 2 forms of ID, get a deed with the name Senator X on it, be, in all appearances, a legitimate owner of property, and in that way, I can enter into multiple agreements for sale, take the deposits from multiple suspecting victims who are unsuspecting, and walk away with their money. And this bill is designed to tackle fraud in the context of Trinidad and Tobago. This bill is designed to tackle corrupt people who have executed agreements for sale, who then go and execute conveyances, who pay their stamp duty, and who never register their conveyances because there's no law to compel them to register conveyances. And what happens is, when law enforcement goes to look at the property that they believe is under investigation, it will show up in the name of the old owner. That happens every single day in this country. This law puts an end to that. That is why so many people are afraid of this law, including lawyers. Let me repeat that. That is why so many people, including lawyers, are afraid of this law, because there is rampant fraud in this country, and lawyers know it. Madam Speaker, Madam President, Senator Mark raised the issue of the private register and said that the issue should be that we should have public registers. May I ask what time is full time, Madam President?
You finish at 1 minute past 3.
Much obliged. Madam President, the Law Association of the Republic of Trinidad and Tobago asked for the closed register. We agree with the closed register because secret trusts are a principle of trusts. And secret trusts in respect of land, be they for family arrangements, etc., they are permitted by law. What we are compelling for the first time is that that law ought to be registered. The trust ought to be registered, kept in a private register for a number of reasons. Number one, the European Court of Human Rights struck down public registers for trusts. They held it to be unconstitutional. Number two, the stakeholders have asked for it to remain private. Number three, we allow for the Trinidad and Tobago Police Service, the FIU, and the court to have access to those registers. Further, we are keeping within precedent in the non-profit organizations law, in the real estate agents law. Anything involving sensitive personal information was kept in a private register. Further, if we were to try and breach that right, that privacy right, right to private life, even though it's not absolute, we'd require a 3/5 majority. Further, what Senator Mark attempted to do today in the most interesting, and I say deplorable of ways, was to paint a story by asking a series of questions. Whilst I was sitting here, I pulled up the company's registry, and I went to deal with the example that Senator Mark dealt with. The mechanism of abuse of trust is because a trust agreement that is used right now to escape the true owner, the beneficial owner being known, those are never registered. Those agreements are never registered. All that they do is they pay $25 stamp duty on the declaration of trust. Senator Mark raised an example of a company called Canon, which bought from Century 21. He then said Belgrave bought from Canon. And he said in 2012, that there was some degree of scandal, and he asked a question that the Minister of Finance should speak to this. So I went to the company's registry, I pulled up Belgrave, the company, I called the Minister of Finance, and I can certify today that the Minister of Finance has confirmed that a company named Belgrave was the subject of purchase of shares by he and his wife. He bought that shareholding in December 2012, and he paid $7.5 million for the transaction. So all of that hurrah and attempt to create scandal that Senator Mark raised is to be completely ignored, and the questions are now completely answered. Whatever happened between Belgrave and Cannon is not column input. Wasn't in the transaction and wasn't there. So, Madam Speaker, let's get on to a few of the issues raised by Senator Hussain, who raised it in the context of an echo that many other senators had. This law does not propose a change in the law as we know it for when title passes. The amendments that we propose to the bill say that the transaction is made effective at the date of execution. You have an obligation to register the conveyance, but it is effective at the date of execution. What does that mean? Madam President, one can sign a deed in December 2020, register it on or before the end of December 2021. When you register it, it is effective as of December 2020. We do not change the law of equity in any form or fashion. Under the Real Property Act, title only passes on full registration. We do not deal with the law of equity. We preserve the law of equity. What is the law of equity? Madam President, put quite simply, the law of equity is the law of fairness. You can own something in law, like a piece of land, in two ways, equitably or legally. If I go to a bank and I ask a bank to lend me money, I convey the legal title to the bank. I hold on to the equitable title. It's like taking a dollar bill and tearing it in half. You give the bank half of the dollar bill, and you keep half. For the bank to sell the property, they must get your equitable ownership by a mortgagee sale, so they get your half of the dollar bill. For you to get back your property is called the equity of redemption. You get back your redemption when you satisfy them by paying, and you unite the other half of the dollar bill here. We do not change the law of equity in any form or fashion. All that we are doing is saying that you have to register your instrument. As a bit of trivia, Madam President, whilst I was sitting here, I signed no less than 15 deeds of gift extension of time. Madam President, without bringing you into the debate, any Minister of Legal Affairs will know that Section 18 of the Registration of Deeds Act says if you have a deed of gift or a settlement, that you have a time frame of 12 months to register under Section 18 of the Registration of Deeds Act. And you are exposed to up to $2,000 in penalties, because the Registrar General, under the existing law, being a saved law, has quasi-judicial functions to exercise a discretion as to penalty. Madam President, we are removing that from the law. We are removing Section 18. We are harmonizing it now so that every registrable instrument, every conveyance, every deed of gift, every settlement, all of them must be registered, just like deeds of gift, within 12 months. But what we do is we allow you to apply for an extension of time up to a maximum of 24 months, 2 years. The Registrar General has no discretion whatsoever. The Registrar General only accepts the instrument and registers it. No discretion. After the 24 months, you go to the court and you tell the court why you should have the option to extend out of time. Let me repeat what I said earlier in a slightly different way. If you compare the registration of deeds against a mortgage bill of sale, a mortgage bill of sale is where you do a loan in a bank for a car, you're buying a car, you want $50,000 from the bank, you give them the car, you do a mortgage bill of sale. The mortgage bill of sale must be registered within 7 days of execution. We are saying if you do a deed for conveyance, you're buying a piece of land for $10 million, $20 million, $500,000, you have to register it within 24 months, otherwise you need the court's extension of time. That is 7 days less than 365 multiplied by 2. In other words then, Madam Speaker, it's disproportionate. We give that 2-year time frame because of the vicissitudes or the complexities of the transactions. We also ask, Madam President, for the registration of a contract. And in registering a contract for a registrable instrument, which includes conveyances, etc., what we're saying is, let your contract be produced. Why? It is perfectly legitimate for people to enter into complex contracts, for them to apportion the purchase price. You might have an agreement for sale to buy a piece of land for $2 million. You might actually have the conveyance at $1 million. That's perfectly lawful if the rest of the purchase price is fairly expressed in terms with the Stamp Duty Act. For instance, chattel receipts can be used in a legitimate way, and that is always the case, because if I produced a deed which sold a property for $1, let's assume I had a deed that said I bought the property for $1, the law is that the stamp duty that is paid on the $1 deed is to be assessed by the Board of Inland Revenue. So they will come along and say, even though you actually paid $1, your stamp duty to be paid is market value stamp duty. So there's nothing wrong with that. The problem is there was a gap between the agreement for sale and the conveyance. Now, Madam President, it is Senator C. Prasad's contribution was on the law as it presented itself in the bill. Senator C. Prasad explained to me that she was not aware that the amendments had been circulated since last week, and I should say on her behalf now, she's not present, but she did tell me that as a member of a law firm, J.D. Saley and Company, that she omitted to say that she is aware that that law firm was on the record for the C4 committee in providing comments. So she said in the event that there's any conflict of interest, she wanted to declare it, and so I'm doing so on her behalf, because the Honorable Senator said that expressly, so that she's covered under our standing orders. So, Madam President, when we look to the issue that has come up, whether there can be an increase in costs, first of all, attorneys at law in non-contentious business in relation to land, they are guided by a scale of fees. You cannot charge nilly-willy. You are obligated to observe the scale of fees. Secondly, what this law actually does is to reduce the runaway cost on properties potentially. Why do I say that? Very often in an unregulated real estate industry, you would have real estate agents who are telling purchasers, if you don't buy, somebody else wants to buy, and somebody else wants to buy, $500,000 more, $1 million more, and a bidding war starts. What this does by having a register of contracts is that it allows you to know the state of a contract and what the price is actually. Is that unreasonable? Is that a fetter of your right to property or interest? No, it's not, because all that it is, just like Senator Sober said, it's reflective of the Roman Dutch system. The ease of doing business in Jamaica, the ease of doing business in Guyana is simpler because they have a system closer to what we're bringing into law today. The ease of doing business goes in a positive direction for Trinidad and Tobago by having certainty of contract, by having certainty of title, by eliminating fraud, because when people have agreements for sale and they don't agree that it is at an end, they go to court for specific performance, or for return of their deposits. They go to court anyway. All that this registration of contracts does is to provide one location in an ease of doing business sense. 5 minutes?
5 minutes, Attorney General.
Much obliged. One location for ease of doing business that the registry can find. Somebody raised the issue as to whether your professional indemnity insurance would go up. No, it'll go down. Why? Because number one, you have certainty of transactions. The attorney has a better understanding of the risk on the title for the first time ever. The attorney has a certainty that if an agreement is not registered, there is none. The attorney has a certainty that if the conveyance is not registered, that there ought to be a reason. If the reason is not there, because we provide for the ability to give reasons, if the reason is not there, it means that there's no further transaction on the property. So the risk on the title is better managed. And we therefore allow for a reduction in professional indemnity insurance and a better position. Now, Madam President, who could have complaint with an attorney at law being under a positive obligation in law, a statutory duty to tell a purchaser what the risk of the transaction is? Who could complain with that? When we often see at the disciplinary committee, people coming forward, clients coming forward to bring their attorneys before the committee, complaining that the lawyer did not exercise proper professional diligence in explaining transactions. This is a protection for the lawyer. This is a protection for the client. It is a protection by way of certainty on the title. Let's deal with the cost of the transactions itself. Madam President, that's why we did a precedent of forms. Attached to the law that we have before us, the bill, we have a compendium of forms. Form A, B, C, D, E, E1, E2, etc., GHI. We have precedented the forms to make it easy to give notification. Now, some people may ask, well, if you're going to go for an electronic system and there's a query on the title, how do you deal with that? Simple. We do that every day. When you file a company's document or you file anything under the Real Property Act, a query notice is issued, and the attorney at law is told there's a query on your memorandum of transfer, there's a query on your system, there's a query on your form. Now, Senator Hussain was raising the issue about list pendants and caveats. The Honorable Senator allowed me to answer the point. I observed that there was a small confusion. I don't think it was intentional. Caveats are solely for real property transactions under the RPA, and caveats have a specific system of existence. We did not go as far as what Senator Sobers had recommended in the Roman Dutch system. We actually have it in the bill, what we're proposing by way of amendments to delete it, where the registrar determines whether the agreement for sale is over, you establish a priority listing. We've deleted all of those things because of the complaint that that would be the Registrar General exercising a quasi-judicial function. So we took it out. In the amendments, you'll see that we propose that. But whether a contract amounts to a lis pendens de facto, look, is a purchaser going to be put off by the fact that somebody has an agreement for sale that's not yet at an end? That's very simple to manage. Better contract provisions, which is why we have said attorneys at law are to be the people to handle agreements for sale. Attorneys at law know that they charge anywhere between $500 or $750 for an agreement for sale. And I want to say this, real estate agents, when they do these transactions, or justices of the peace, real estate agents earn up to 3%, 5% or 7% on the transaction. Attorneys at law earn under 0.75% of the transaction. Their fees are strictly regulated. Madam President, I'll end by saying this. Under the FIU, it's not sufficient. Of the 5,000 lawyers on the roll of attorneys at law, we only have 700 lawyers registered at the FIU. It's just not good enough. This law is designed to kill corruption, better certainty of transactions, and protect interests in this country. It will ease the doing of business, and it is appropriate. In those circumstances, I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Registrar General Act, Chapter 1903, the Registration of Deeds Act, Chapter 1906, the Conveyancing and Law of Property Act, Chapter 5601, the Real Property Act, Chapter 5602, the Stamp Duty Act, Chapter 7601, and the Registration of Title to Land Act 2000 be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Registrar General Act, Chapter 1903, the Registration of Deeds Act, Chapter 1906, the Conveyancing and Law of Property Act, Chapter 5601, the Real Property Act, Chapter 5602, the Stamp Duty Act, Chapter 7601, and the Registration of Title to Land Act 2000.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled The Miscellaneous Provisions, Registrar General, Registration of Deeds, Conveyancing and Law on Property, Real Property, Stamp Duty, and Registration of Title to Land Bill 2020 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that a bill entitled The Miscellaneous Provisions, Registrar General, Registration of Deeds, Conveyancing and Law of Property, Real Property, Stamp Duty, and Registration of Title to Land Bill 2020 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. So at this stage, the list of amendments circulated on behalf of the Attorney General. I'm seeing that members are receiving them, the list. Senator Mark, I believe you have a list of amendments as well, which will be circulated shortly. Yes?
Madam Chair, why didn't the Attorney General circulate these things at the beginning of our debate? I'm now seeing,
Well, before I call on the Attorney General to respond, I believe that a marked up copy of the
This
bill
is a marked up copy?
with these amendments had been circulated. So the amendments still have to be circulated separately. Correct, Attorney General?
So this is the marked up version, Attorney General?
Yes, so Madam President, thank you so much. We did much better than just circulate the amendments. We went as far as to put it in the context of the bill. So last week, because we had met with the Law Association and we knew that we wanted amendments, we didn't want to catch senators by surprise. So what we did is we thought it easier for senators to read the proposed amendments in the bill as marked up. So we sent a color-coded marked up with amendments in red, with strike-throughs, etc. And in fact, all of the opposition senators have referred to those amendments in the course of this debate. So what is now circulated is reflective of exactly what is in that marked up version of the bill.
Attorney General.
Yes, Madam President, in the beginning of my contribution in piloting the bill, I noted for the public record that the Law Association had written to me, the President of the Law Association, by way of letter today's date. In that letter, the President of the Law Association thanked me for meeting with the Law Association on the several occasions and noted that we would be sitting to debate the bill today. In speaking with the Law Association, they have asked for one further meeting to narrow a few issues between us. And in those circumstances, we proposed, and we did today, complete the debate. We're now at committee stage. What we're asking for, and the Leader of the House will treat with us just now, is that we adjourn this committee of the whole to allow for that final meeting with the Law Association, and that we will continue this committee stage, subject, of course, to the President's ruling on another occasion, which we expect to be next week.
Senator.
No, Madam Chair and Attorney General, I have been advised that there were some discussions surrounding this matter, and that the view was expressed because of the gravity and complexity of the proposed changes, that it ought to have been referred to a select committee of the Senate rather than just adjourning and having another face-to-face discussion with the Law Association. So I don't know if we are getting mixed signals, but I would have preferred, because of the gravity and the far-reaching nature of this legislation, that we could have placed it before not a joint select committee, but a special select committee.
Madam Chair, that has not been the suggestion of the Law Association. We have been in consultation with all stakeholders since 2017 on this law. We're now in 2020. We've spent umpteen hours, in particular with the Law Association. We've dealt with the Bankers Association, the FIU, the Chief State Solicitor, a wide host of stakeholders. The Law Association, we spent 2 Zoom meetings, as Senator Ramrat raised in his contribution. We spent 2 hours discussing the word mortgage. So we've had deep consultation with them. They have, as I understand it, one issue left, the issue of the contract, because the amendments that we see circulated are largely from the association, from the Law Association's comments coming from their committee. This particular provision is not a complicated law that we're doing. We're leaving the law of equity exactly as it is, the effective date exactly as it is. We're asking for deeds to be registered within 12 months or 24 months, depending upon extension, and we are leaving the common law largely exactly the way it is. Further to that, we're only adding in, if you have an express agreement for sale, register that as well. Those are the 2 things that we are doing, nothing more than that.
That the committee's deliberations be postponed or adjourned until next week. Is that what I'm being told?
Yes, I think the Attorney General is saying that the deliberations of the committee will proceed next week. Attorney General, is that correct?
Yes, Madam President. To allow the Law Association to make one last meeting, which we're doing. Senator Vera said something. He said he'd like to have the imprimatur, if it's possible, of the Law Association. 95%, if not 99% of this represents their imprimatur. Out of an abundance of caution and in deference to the Law Association's request, the government wishes to have one more meeting with them. They, in fact, held meetings with the opposition and with the independent bench, and therefore we want to have that meeting with them so that we can make sure that we know exactly what our issues are, if any.
Okay. Honourable Senators, at this stage there are some technicalities that the Attorney General will now treat with.
Madam, at this point, may I?
Yes.
So, Madam Chair, in accordance with Standing Order 6814, I beg to move that progress on the bill be reported to the Senate.
Honourable Senators, the question is that progress on the bill be reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate will be resumed. General.
Thank you, Madam President. Madam President, I wish to report that a bill entitled An Act to Amend the Registrar General Act, Chapter 1903, the Registration of Deeds Act, Chapter 1906, the Conveyancing and Law and Property Act, Chapter 5601, the Real Property Act, Chapter 5602, the Stamp Duty Act, Chapter 7601, and the Registration of Title to Land Act 2000 was considered in committee. However, the deliberations on the bill were not concluded. I therefore seek leave of the Senate to resume the committee stage on, is that Monday? Tuesday, on June 9th, 2020.
Honourable Senators, the question is that the committee stage of the bill be resumed on Tuesday, June the 9th, 2020. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The committee stage of the bill will be resumed on Tuesday, June the 9th, 2020. Leader of Government Business.
Thank you very much, Madam President. Madam President, I beg to move that the Senate do now adjourn to Wednesday, June 3rd. That's tomorrow at Wednesday, June 3rd, 2020 at 10 a.m. During that sitting, we plan to do the House amendments on the Interception of Communication Amendment Bill, and time permitting, we will attempt to do the Urban Planners Bill.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised. Senator Mark.
Thank you, Madam President. Madam President, it will be recalled that on the 15th of May, 2019, just over a year ago, Madam President, and following a successful regional CARICOM workshop held here in the Parliament and supported by the Government of Canada, I took the opportunity to table a resolution before this Honorable Senate inquiring as to the continued failure by the government to promulgate the Bacteriological Weapons Convention action of 2012. At the time, and given the resolution outlined, I sought to highlight in particular, Madam President, the public safety and public security implications of this very important act of 2012, noting in connection therewith the growing risk of biological weapons in the global community of today. Madam President, fast forwarding 12 months later, and given developments pertaining to COVID-19 in the last 5 months in Trinidad and Tobago and around the world, I do not believe I need to dwell too long on the fact that the continued failure by the government to promulgate this crucial act now represents a clear and present danger to the people of Trinidad and Tobago. Madam President, while this act may focus more specifically on deliberate biological attacks, it is to be observed that had full promulgation and implementation taken place closer to the date of adoption of this act, now some 8 years later, because it took place, Madam President, in 2012, certain provisions therein may well have been of some useful application in the context of the current pandemic and the challenges it poses to us in this country. Madam President, legislation implemented to address deliberate biological attacks can also mitigate the risk of unintentional biological weapons attack. Madam President, here I would like to draw to the attention of this Honorable Senate, in particular, to Articles 7 and 10 of the Biological Weapons Convention itself. It should also be noted that in the past 3 months, considerable and more credible, reputable international commentary is now emerging, highlighting that the likelihood of the next pandemic being deliberately, not accidentally induced, is much more probable and likely than heretofore has perhaps been the case. And therefore, Madam President, non-state actors, including terrorist organizations, have not been blind to the effects of the pandemic that the country and the globe has been experiencing. Here in Trinidad and Tobago, we have not been strangers either to the threat of this development or terrorism in this land. Madam President, in light of what I have advanced, I am again requesting of the Honorable Minister of Foreign and CARICOM Affairs to inform the Senate as to what steps, if any, have been taken to address the issues that he indicated still required treatment before the act could be proclaimed in the intervening 12 months since we last discussed this matter in this honorable chamber. Madam President, the well-being and basic safety of the people of Trinidad and Tobago deserve nothing less. And therefore, Madam President, I would like to call on the Honorable Minister of Foreign and CARICOM Affairs to really address this issue and to really advance to the Senate. Where do we stand as a country, both in terms of the promulgation, the issuance of regulations, as well as what was highlighted when the Honorable Minister last addressed the Senate, that there are some issues that have emerged that require treatment before the act can be proclaimed. And he went on to say, Madam President, in closing, we continue to persevere to achieve the laudable aims of the convention. So, Madam President, this is my submission. It's the third time in 5 years I have raised this matter, and I'm hoping that the Honorable Minister will be able to bring some kind of finality to this very important matter. I thank you very much, Madam President.
Minister of Foreign and CARICOM Affairs, you have 10 minutes.
Thank you very much, Madam President. Indeed, it falls to me to bring some enlightenment to a matter that comes from a period 2012. Indeed, the years would have passed 2013, 14, 15, and it continues. Madam President, the Bacteriological and Toxin Weapons Act 2012 was created to give legal force to the Convention on the Prohibition of the Development, Production and Stockpiling of Bacteriological and Toxin Weapons, and on the destruction to which Trinidad and Tobago acceded in July of 2007. Among the stipulations of the Act is the requirement to establish a Biological and Toxin Weapons Committee, which is to consist of competent professionals from several fields to accomplish its work. This has to be accomplished before the Act may be proclaimed. Unfortunately, addressing the challenges that have arisen and which have precluded taking the action required to facilitate proclamation and subsequent operationalization and implementation of the Act has become a more protracted exercise than anticipated. Madam President, renewed effort will certainly be expended by the relevant entities towards ensuring that the necessary action is taken to allow for the proclamation of Act number 4 of 2012. I thank you.
Senator Mark.
Madam President, the other matter that I wish to bring to your attention and to this Honorable House and Senate, that is the need for the government to address almost post haste. Madam President, it is almost the end of this PNM period of service over the last 5 years since they were elected to run this country. And they came on a platform of morality in public affairs. They accused the outgoing administration of bid rigging and corruption and lack of transparency and accountability. This government, Madam President, close to 5 years in office, having told the country that they will, as a matter of urgency, upon entering office, operationalize by proclaiming the public procurement and public disposal of land legislation. Madam President, that was all talk by the PNM to fool and to mama-guide the population. It is now 5 years later, Madam President, and this public procurement law has not been proclaimed in its entirety. It has not been operationalized. And at the same time, Madam President, billions upon billions upon billions of monies, public monies, have been spent, have been expended by this government without any serious tendering and or procurement procedures. Madam President, whether it is the purchase of fast ferries out of Australia, whether it has to do with 2 Cape-class vessels that are costing the country $300 million that it cost the very Australians to purchase some time ago, whether it is contracts issued to deal, Madam President, with road works, whatever element of contract that is involved, Madam President, as we witnessed during COVID-19 lockdown, where the government came to this parliament, got $11 billion from the Heritage and Stabilization Fund, amended the Loans Act to get another $10 billion. And Madam President, they have been spending monies as if it's going out of style without any form of accountability. $20 billion they have taken from us. We don't know where that money has gone. We don't know how they have spent that money. What we do know is that there are companies that are getting billions and billions of dollars to raise in loans for this government. I refer to NCB Global Finance that has been given contract after contract and without any transparency or accountability. Madam President, I was shocked to see this fly-by-night organization whose balance sheets was less than $80 million in 2015. Their asset base was $80 million. And today, Madam President, through government loans and government contracts and government activity, that organization is now a multi-billion-dollar outfit. You know, the last time, Madam President, they were called upon to raise a bond valued at $1.5 billion for this country.
Senator Mark, I normally do not interrupt when these motions are progressing, but I may be mistaken, but I think that this specific matter you're treating with right now was dealt with on a previous motion in the Senate. You're dealing with procurement, but you're now going into an issue that has already been debated. No, don't argue with me, Senator Mark. Continue with your motion, but proceed.
So, Madam President, the reality is that the government has not been able to proclaim the law, and that is why all these things are happening before your very eyes and before the people's eyes. Madam President, may I remind this Honorable Senate that on the 28th of February 2020, the Minister of Finance told the Parliament, and I quote, "The last correspondence from the regulator was received by the Minister of Finance on December the 18th, 2019. Following that letter of December 18, 2019, the draft regulations and proposed amendments to the Act were submitted to Cabinet and sent to the Legislative Review Committee for final review. That was in February of this year, Madam President. He said, barring unforeseen circumstances, it is anticipated that the final amendments to the Act will be laid and debated in Parliament by March of 2020, followed by the regulation shortly thereafter. Madam President, March has come and gone. March of 2020 has come and gone. And there is no regulations, there are no regulations tabled in this Parliament, and there is no final amendments to the Act as was proclaimed and indicated by the Minister of Finance. Madam President, the absence of the proclamation, full proclamation, because when we were there in 2014, certain aspects and elements and or provisions of the legislation were proclaimed, but it was left up to the incoming administration to do the final proclamation and operationalization of the legislation. But Madam President, we have not been lucky under this government. The government, Madam President, has failed, and they have a lot to answer. They have a lot to answer because, Madam President, if you want to deal with corruption, if you want to deal with waste, if you want to deal with widespread wastage, right, of our resources and theft of public money, we need, Madam President, to ensure that the public procurement legislation is proclaimed, is operationalized, and in action, Madam President. So today, I'm calling on the government to take action, because it will take a new administration led by the UNC to actually promulgate and operationalize the actual act that I'm dealing with here today. The government has failed to do it, Madam President, and I call on the government and whoever the spokesman is this evening to give this Parliament and the Senate a clear, unambiguous, unequivocal commitment that they are going to actually proclaim and operationalize the public procurement law. The people are crying out. Justice demands that that be done, Madam President. We can no longer continue with this slapdash approach to public monies in this country. And Madam President, we have spent close to $300 billion, and there has been no real public procurement legislation to look at how the government has been spending our money in terms of awards of contracts in this country. Madam President, I thank you very much.
Minister of Agriculture, Land and Fisheries.
Madam President, I'm happy to be here because if I was a stranger listening at home, I ran the risk of being convinced by what I call a dubious, frivolous, and foolish motion. Madam President, there's nobody better positioned in this House, possibly in this Parliament, to understand the oversight for public procurement, even in the absence of the new legislation, than Senator Mark. I don't think we've had a situation in history of this Parliament where a member has served, as Senator Mark serves now, on the PAAC, the committee that deals with expenditure of public funds, based on the allocation in the budget, Public Administration and Appropriations Committee. He sits on the PAEC, he sits on the PAC, and he sits on the Committee on State Enterprises. And Senator Mark must know that this government and no government operates in the absence of procurement, legislation, regulation, and oversight. The Central Tenders Board continues to exist. The Defense Force Act contains provisions for procurement to be done for the military. The state enterprises have rules governing their procurement. The RHA, enshrined in the legislation creating the RHAs, have rules relating to procurement. So this government has not been operating in the absence of procurement, legislation, regulation, oversight, including oversight from my friend Senator Mark. The second point I would make, Madam President, is that he's used this slingshot motion to continue to promulgate a massive piece of misinformation relating to NCB. And I just want to say one thing, Madam President. I sit in the cabinet, and I see those notes when they come. And Senator Mark, every time you cast aspersions on the funding and the awards of mandates to fund, you are casting aspersions on the permanent secretary in the Ministry of Finance and those public servants. Those are the ones. And then the third thing I want to say is this, because that is where the recommendation comes from, and you know, because you were a former minister and you were in a cabinet. And I don't know you to be sleeping in cabinet or anything like that. And the third thing is this story about delay. Within the first 2 months of coming into government, we laid a bill to amend the Procurement Act of 2015. And that had to deal with removal of the regulator, reporting to the PAC, and the disposal of state lands. That bill was referred to a Joint Select Committee and completed its process and was passed, assented in June 2016. So the first 10 months went in preparing the bill and getting it through this parliamentary process. 15 months after we came into government, we had a second bill laid on 19 December 2016 that had to do with reducing the term of the regulator. That was assented March 2017. The board, now being in a position, His Excellency at the time, to appoint a board, the board was appointed on 12 January 2018. The first employee was hired July 1st, 2018. And the first meeting the Office of the Procurement Regulator had with the Ministry of Finance was 26 October 2018. So it took 3 years and 1 month, Madam President, for the procurement regulator to meet with the Minister of Finance, the Chief Parliamentary Counsel, and the Solicitor General. And that is because of things that had to be done. The first submission of the draft regulations was in November 2018. And Madam President, that is almost 40 months after we came in office, we received the first draft. There were meetings between the procurement regulator and the Ministry of Finance, and 83 days after receiving the first draft, the Ministry of Finance submitted comments to the OPR. Thereafter, there were exchanges between the OPR, the Ministry of Finance, leading up to the completion of the technical review by the Ministry of Finance of the regulations, the draft regulations, in June 2019. Thereafter, Madam President, in September 2019, the regulations, the draft regulations, were submitted to the Cabinet and referred by the Cabinet to the Legislative Review Committee. And in March, Madam President, March 2020, the LRC commenced its work with the Office of the Procurement Regulator on the regulation and on certain proposals to amend the Parent Act. And I would say, Madam President, yesterday, while the LRC was meeting, we received from the Office of the Procurement Regulator the feedback on the proposals to amend 4 sections of the Parent Act. And we also recently received the regulations, the latest version of the regulations, which are being reviewed by the CPC. Madam President, this government and the Minister of Finance in particular, contrary to what Senator Mark, because he never did embark on that motion, he was all over the place. Contrary to any suggestion he has made relating to delinquency or delay, I have set it out exactly how we've proceeded. The government intends to lay in the Parliament the amendments, a bill to make the amendments. We intend to lay the regulations, and the government intends, as promised, to deal with having in place this new procurement regime. But I close by saying there currently exists a procurement regime used by my friends when they were in government and used by us with all the oversight mechanisms in place, including oversight by this Parliament. I thank you.
Honourable Senators, the question is that this Senate do now adjourn to Wednesday, June the 3rd, 2020 at 10 a.m. Those in favour say aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Wednesday, June the 3rd, 2020 at 10 a.m.